Yes, it's all.
My Lord, I was about to refer you to the IBC Act, which is in Bundle 2, tab 35, page 526, and E page 1083. First you get the index, obviously, and then at page E page 109, page 522, the beginning of the Act, and its title, and it's an Act to provide for the incorporation, registration and operation of international business companies. Over the page at 1090, at the top, you've got a reference to the Companies Act, which means the Companies Act of the Bahamas, and court means the Supreme Court or judge thereof. Further down, registrar means the Registrar of Companies, and the Registrar of Companies means the Registrar General. That, to my mind, links the IBC to the companies, the Ordinary Companies Act.
Sorry, I was going to ask you, because I thought we haven't got the whole Act here, of course, but...
Yes, you have. It is the whole Act at tab 35, starting at page 1083, the E page 1083. It's Bundle 2.
The core, I think about the whole...
The core bundle's just
Anyway,
got some of the
never mind.
sections.
I was just going to ask you, I mean, is the only link to the main companies legislation the occasional reference to Registrar of Companies, or no? There's a reference to Companies Act, but are there any? There's nothing in the Act which says where, unless otherwise stated, the Ordinary Companies Law shall apply, or anything like that. No,
It's not.
so
Except that I think, as you read through it, there seems to be an assumption that aspects of the Companies Act, for instance, the Registrar of Companies, it seems to refer back to the structure in place in the Bahamas for the Companies Act.
Is this a very much a Bahamas concept, or does one find it in other jurisdictions?
The International Business Companies Act, I think you find it in some of the other, if I can call them offshore jurisdictions. Yeah. I think there's one in Cayman Islands and BVI.
Yeah. All right, thank you.
I haven't checked whether there's one in Bermuda.
I see under subsection 2, a company that's incorporated under the Companies Act, or indeed a company that's incorporated under the laws of a jurisdiction outside the Bahamas, can be a company incorporated under this Act.
Yes, there's quite a bit of cross-references, which is what I want to take you to. So definition, section 4, subject to section 21B, the Financial Corporate Service Providers Act, no person other than a bank or trust company licensed under the Banks and Trust Companies Regulation Act shall incorporate an international business company unless such person is licensed and approved under the Financials and Corporate Service Providers Act. So it's very much geared to financial institutions. Section 12, on E page 1095, you will see
I'm not sure where we find that in the hard copy. I'm sorry?
Page 528 of the bundle.
We're in volume 2.
Yes, we're in volume 2, sorry.
Complete version now.
Oh, I see.
It's tab 35,
35, yeah.
which has the whole Act.
We're on section 12?
Yeah.
Yeah.
Well, that's just, again, to show it's geared to overseas companies. So it accepts companies which have foreign incorporation names. You can continue as a company incorporated under this Act with the old names.
So the concept of continuation, as I understand it, is you start life as a company under the 1992 Act, but you have an option, if you want to be within this regime, to continue your registration as a company in the Bahamas, but under this Act,
Yes,
which is a separate regime from the 1992 Act.
it is a separate regime, save that in my submission there is quite a lot of cross-references,
Yes. Thank you.
and I use that to back up my submission that the companies winding up rules can apply to the IBC Act.
But you're going to come back to your
I'll
argument
come
on that.
back to that, yes.
But at the moment, it looks as if you can't sort of stop halfway between the two. You're either incorporated under one regime or another.
Yes, yes.
That's true if you started abroad,
Yes,
are imported.
yeah. Section 13, the next section, states that the currency in which the shares can be issued can be different currencies. Then if we whiz over to section 38, which is hard page 544 and e-page 1111. That's a company shall at all times have a registered agent in the Bahamas. And then again, no person can act as a registered agent unless he's licensed to carry on the business of financial and corporate services pursuant to the Financial and Corporate Service Providers Act. So in my submission, this is how the Act benefits the Bahamian economy, because although it's actually geared at international companies, they have to have a service provider in the Bahamas. And as I understand it, there's a very large financial and corporate services sector in the Bahamas, which is what this Act is designed to assist. Going on to page 549, hard copy, section 48, e-page 1116. You'll see that the directors of the company can meet wherever they like, either in the Bahamas or out of the Bahamas. And similarly, section 60 at page 1119 or hard page 552, shareholders' meetings may be held within or outside of the Bahamas. And then, as my Lord Sales points out, under section 84 to 85, which is hard copy 571 and soft copy 1138, companies incorporated outside the Bahamas may continue as a company inside the Bahamas. But section 88, which is page 575 or E page 1142, companies incorporated under the laws of a jurisdiction outside, if it moves outside, it's still going to be subject to the laws of the Bahamas. So subsection 3, the company continues to be liable for all claims, debts, liabilities and obligations that existed prior to its continuation under the laws of the jurisdiction outside the Bahamas. Then next page you get to part 9, which deals with the winding up, dissolution and striking out. Provisions at 93, 95, section 95, which is page 1145. Which is in the application to the court for the winding up of company shall be made by petition, and such petition can be presented by the company director or creditors or contributories. And 96, a judge in a court may do in chambers anything which the Act is authorised to do in the winding up by the court. Sections 114 and 115 on hard copy 583, 1150, soft copy. Just the usual powers of the courts to order delivery up of property.
So sorry, what was the electronic reference for that one?
Sorry, it's 1150.
Thank you very much.
So it's the powers of the court to require delivery of property and the powers of the court to order payment of debts by a contributory where a company is being wound up. From section 142 onwards.
Is section 112 relevant? That seems to say that the court shall cause the assets of the company to be collected.
Well, yes, because that's so the court oversees what the liquidators do. From section 142, which is E page 1159, page 592 hard copy. You get the heading winding subject to the supervision of the court. So that's
Sorry, which section?
compulsory winding up, in other words.
Where have we reached?
1159.
Section 1.
It's just the heading showing the following sections apply to a compulsory winding up, basically. In that section, you get section 153 and 154, soft page 1162, hard copy 595, I just want you to note the position of section 154, which my learned friend relies on to say that as a result of section 154, the bankruptcy rules apply. And in my submission, these sections all refer to a creditor who's proving in the liquidation. So 153 is the debts to be proved. 154 is the respective rights of secured and unsecured creditors and to debts provable and valuations of annuities, future and contingent liabilities. That's all about how a liquidator deals with the proofs and can't think of the right word now. Priority of the priority and valuations of the debts, the provable debts. And then in the next section, in 155, is the preferential payments. I should point out that the Bahamian Companies Act 1992 has exactly the same provision in it. As it does exactly the same fraudulent preference provision. So both those sections cross-refer to bankruptcy, but that doesn't mean that you interpret this Act in accordance with the Bankruptcy Act or the bankruptcy rules. And of course, pre the Insolvency Act, in the old Companies Act, we had the same. Our fraudulent preference provision cross-referred to our Bankruptcy Act for the test of the fraudulent preference. Nobody ever suggested before the Insolvency Act 1986 that we ought to be following the bankruptcy rules as opposed to the company rules in a winding up, so far as I know anyway. And then 2 pages further on, so page 599, hard copy, soft copy 1166. The fraudulent preference section, which is the subject matter of this case. And the following one, section 161, is the fraudulent trading stroke misfeasance section, which is followed by the criminal responsibility in 162. Now I want to jump to part 12, which you won't find in the Ordinary Companies Act, which is at hard copy 609.
Just before you leave 160, it follows from the wording, is it, that you can have a fraudulent preference of a third party, not just the recipient of the payment.
Yes.
And your remedy would still be against the recipient.
Yes, yes, my lady.
Thank you.
It's 1176, soft copy, 609, hard copy. See, it's part 12, which are the exemptions, which shows that an IBC company, a Bahamian IBC company, is exempt from certain taxes, in particular the exchange control regulations, which they have in the Bahamas, and stamp duty. So, section 187. And 187.2 says, subsection 1 shall not apply to a person who is a resident of the Bahamas within the meaning of the Exchange Control Act, or to a company incorporated or continued under this Act, if a resident within the meaning of the exchange control regulations. So in other words, these tax exemptions apply to the non-Bahamian companies. But if you're a Bahamian company who wants to be an IBC, then you're going to be subject to the local taxes.
I'm sorry, so not the other way around. Look, 1871 gives an exemption from tax, which by subsection 2 is confined to non-residents.
Yes, yes, my lord. And similarly, further down, it's the stamp duty, it's equivalent stamp duty. And subsection 7, any resident of the Bahamas within the exchange control regulations has to obtain permission from the central bank to acquire shares. And then subparagraph 8 on e-page 1178. These exemptions will remain in force for 20 years from the incorporation of the company. And then subparagraph 9 is the Exchange Control Regulations Act and the regulations made thereunder shall not in any manner apply to a company incorporated under this Act. That's the last words which are important. The operations of which are intended to be exclusively overseas. My point of taking you to all those is that it's clear that the whole purpose of the International Business Companies Act was to attract foreign investors, such as mutual funds, hedge funds, banks and trust companies. Indeed, it's limited to financial and corporate service providers and banks and trusts, and these obviously will all be foreign investors, which we saw is the case in AWH. My next proposition under the extraterritorial grasp point is that in my submission, section 160 has extraterritorial grasp. My Lords, for ease of reference, in the respondent's case, which is E page 551 and hard copy page 6, I've run section 160 together with the words from section 72 of the Bankruptcy Act, so you can read it as one section.
Which paragraph?
Paragraph 16 of our case, which is on the top of page 6 of our case.
And your electronic page?
I'm sorry?
Electronic page.
Electronic page is 551.
Thank you, I misheard it. Thank you.
My Lords, section 160 obviously has to be read and construed in the context of the whole Act, not just as the section on its own. And in my submission, in considering whether a statutory provision has extraterritorial effect, there are two principles in tension with each other. One is the comity of nations, and the second one is the universality of the winding up procedure. The principle of comity between nations requires that each sovereign state should be exclusively allowed to govern in its own territory. The principle of universalism is that a winding up order has worldwide effect over the company's assets and their distribution. It's more generally expressed as assets of a debtor should be collected and distributed on a worldwide basis in a single insolvency proceeding. So when a company goes bust, it affects anybody who's dealing with it. It's not just the people within the territory that it's operating. And in my submission, in this case, the universality principle wins hands down. And this is an increase in the world of insolvency. This principle has to grow and has grown as the world has shrunk with the massive increase in ease and speed of communications, and in particular, in relation to this company, the ease of transfer of funds from around the world. It's much easier now for us to transfer funds than it was of yore. Gone are the days when you had to go and get your travel, what were they called? I can't even remember what they're called when you went abroad.
Traveller's checks.
Traveller's check, yes, special checks, weren't they? And my submission is that it's now settled law that the statutory powers to claw back funds in liquidations that have depleted the assets of an insolvent company have extraterritorial effect. There's absolutely no reason why such a principle shouldn't apply in the Bahamas as in any other jurisdiction, particularly the Bahamas being a country that is seeking to attract international investors. And in that respect, I wish to refer to Paramount and Bilter and Oxerim. If I can go first to Paramount Airways, 1993, which is at volume 1. Tab 19, page 903. That was the administrators of a company seeking redress from a bank registered in Jersey under the Section 238 of our Insolvency Act, the English Insolvency Act, which is the transactions at an undervalue.
That contains a built-in statutory remedy, doesn't it?
That's what Sir Donald Nichols found. He starts at, if I could start at page 912 and hard copy 345 at E. He's talking about an aid to construction. My Lords, perhaps you could just read, but starting at the principle, was the principle, that is, of extraterritorialism. It starts with the reference to Clarke. He says, I need only refer to the passages and speeches of Lord Scarman and Lord Wilberforce. Perhaps you could just read that until he starts talking about the sections.
Very sorry, I misheard your E page again.
Sorry, 912.
Thank you.
912 to 913. It's from the Clarke Oceanic Contractors. I picked up the word grasp, legislative grasp. And the final bit of Lord Wilberforce's statement, the contention being that as regards company, the statute cannot have been intended to apply for them if they were non-resident. One asks immediately, why not? And then he refers to the expression any person. And then at page 915, hard copy 348. He talks about the person in respect of whom Parliament was legislating. And at 919, C, and that's hard copy 352. He says, in my view, the solution to the question of statutory interpretation raised by this appeal does not lie in retreating to a rigid and indefensible line. Trade takes place increasingly on an international basis, so does fraud. And this he was talking in 1993, which is over 20 years ago now. Money's transferred quickly and easily. To meet these changing conditions, the English courts are more prepared than formerly to grant injunctions in suitable cases against non-residents or foreign nationals in respect of overseas activities. As I see it, considerations set out above and taken as a whole lead irresistibly to the conclusions when considering the expression any person in the sections, it's impossible to identify any particular limitation which can be said with any degree of confidence to represent the presumed intention of Parliament. What can be seen is that Parliament cannot have intended an implied limitation among the lines of ex parte. plain. The expression, therefore, must be left to bear its literal and natural meaning, any person. And then he goes on to talk about the fact that there's the court's discretion to show they can still, having found there's extraterritorial reach or grasp, it's still in the court's discretion as to whether to actually, in a particular case, grant service out, so that there are safeguards. Can I just check how much time I've got? Is it till 3 o'clock? I've got, I think, haven't I?
Till 3 o'clock. Well, we're due to finish at 3:30.
So I'm going to speed up a bit. In Bilter, I've quoted, actually I haven't completely quoted, I've quoted what Lord Sumption said, and that's Bundle 1, tab 11, page 181, page 748. At pages 225, I think it is. Starting at page 225, soft page 792. This was a carousel fraud, and the application was under section 213 of our Insolvency Act, which is intention to defraud creditors. And I've quoted section 107 in our case, 108. Sorry, 108. Most codes of insolvency law containing provisions empowering the court to make orders setting aside certain classes of transactions which preceded the commencement of the liquidation and may have contributed to the company's insolvency or depleted the insolvent estate. That's at paragraph 108. They will usually be accompanied by powers to require those responsible to make good the loss for the benefit of the creditors. Such powers have been part of the corporate insolvency law in the United Kingdom for many years, as they have been in the Bahamas.
Well, up to a point, isn't it?
We've been able, with the Bahamian law has fraudulent preference and misfeasance provisions, and has done, well, the Bahamas was subject to English law until...
Yes. I was thinking, the sentence just at the foot of page 225, they'll usually be accompanied by powers to require those responsible to make good the loss.
Yes, my lord. The Bahamian jurisdiction doesn't have specific powers.
Nor indeed did
The
1948 regime.
Or the Companies Act 1985 until it became the Insolvency Act.
Mm-hmm. Does this add anything for your purposes to Paramount?
Not really, no. It's just saying, look, Lord Sumption in 2016 was approving Paramount, and he just says at the beginning of paragraph 109, the English court, when winding up an English company, claims worldwide jurisdiction and their proper jurisdiction, their proper distribution, and 101. No, and if I could, I won't read them, but Lords Toulson and Hodge, starting at hard page 253 and soft page 820, basically agree. Yeah. And I won't take you to Oxerim, but that's been followed recently by the Court of Appeal in this country, finding that section 423, which is the voidable it's not, is it? What is it, section 423?
Objection.
It's the intention to defraud case, also has extraterritorial reach. But in that case, he then said, but that case in Oxerim, it was brought by a victim of the transaction as opposed to an insolvency practitioner or officer. And Lord Justice Lewison found that, in fact, they wouldn't allow service out because there were reasons why the Indian jurisdiction and the Singapore jurisdiction would be more appropriate. So it was sort of he went through, first of all, that Section 423 did have extraterritorial grasp, and that the English insolvency, the English CPR rules could allow service out, but in that case, he would exercise his discretion against it because it wasn't, the connection with England wasn't sufficient in that case, but that case was not founded on a liquidation. It was a victim of a transaction bringing that case. So, my Lord, if it applies to ordinary English companies, then in my submission, this extraterritorial reach must a fortiori apply to an international company whose members and creditors will all be foreigners.
And in that first sentence of 109, would assets encompass debts owed to the company as well as property of
Yes,
other
my Lord.
kinds?
Yeah.
No. And a claim for money hadn't received is just one type of debt.
Yes, my Lord. So in my submission there are five. There's lots of reasons why Section 160 should be given extraterritorial grasp in this case. My first point is to pick up on Lord Justice Nichols's thinking in Paramount, and that's he says any person should mean any person, and in our section 160, coupled with the bankruptcy section, we're talking about any creditor, or indeed any person in trust for any creditor. So in my submission, it means exactly what it says, any creditor. It doesn't say any creditor in the Bahamas.
And that's in the context of trying to preserve and protect the pari passu rule, which
Yes.
requires you to look at all the creditors.
Yes, my Lord. If this is, obviously, it will have to go to trial about a fraudulent preference, but if it is a fraudulent preference, then ZCM will be put back in the position that they should have been at the time of the petition, which was to have a claim to get their, whatever it was owed to them, in this case the redemption amount, paid in pari passu with the other shareholders who were entitled to redeem. So in particular, in this case, the creditors, the petitioning creditors, who we saw were told in September that they were only going to get 16% of the amount they wanted to redeem, whereas ZCM got the whole 100% just a few weeks earlier. So one, any creditor; two, to avoid the futility that this Act would have if Section 160 is confined to the Bahamian territory, or to people within the Bahamian territory. I made the point that the Bahamas is as much in the modern world in relation to modern transfer and communications as England is. The IBC is a modern act designed to attract investors. And my learned friend's concern that if this section was given extraterritoriality, then it would mean that also other sections, people would be able to serve things out. And in my submission, as you can see in Oxerim, the court has always got discretion to refuse permission to serve out, as we will see when we get to Order 11, Rule 8. In his case, my learned friend started off referring to Benyon on statutory interpretation, the 7th edition, and he refers to paragraph points, it's in paragraph 4.6 of his case. In his case he refers to paragraph 4.6 or section 4.6 of Benyon. My lord, I didn't have the whole of Benyon in the bundle, but you should have a supplemental paper, I'm afraid, my Lord Briggs, where we go on from section 4.6, and section 4.6 actually said it's supplemented by section 4.8, and it's page 3A of my supplemental bundle.
I'm not sure that I have that. Is it on the electronic?
I sent it, but I'm afraid I only sent it last Thursday. You'd have a hard copy, and it was also sent.
Being handed it. Sorry, thank you.
It was sent by email as well. I'm not sure it's
Yes,
got
I'm
to
sure.
you.
Sorry, my fault.
2A, he says relevant considerations to where an act won't apply extraterritorial, and it talks about the Committee of Nations under relevant considerations. And then the next paragraph at the top of 3A, he has the considerations that may cause Parliament to intend a law to apply outside the territory, and we rely on bullet points, the final 3 bullet points. And add to the bottom one, it says, given the ease at which people may travel and communicate internationally, it may be necessary for an act to apply in relation to things done outside the territory. If the act is to be effective, I would add not just travel and communication internationally, but investment internationally as well. So, in conclusion, my submission is that Section 160 undoubtedly has extraterritorial effect. I can come now to procedure. Once a extraterritorial power has been found, then a route to engage the court has to be found. In England now, we've got a motorway. We've got several motorways. So we've got the motorway of what was Insolvency Rule 12.12 and is now comes under the CPR Rule 6. Just because we've got that in my submission, it doesn't mean that in the Bahamas, their perfectly effective route through Order 11, highway, wasn't the correct route to be taken. It was the correct route to be taken. And this is an important point because the amendments to both the Bahamian IBC Act and the recent and the company's winding up rules, there have been a couple of amendments quite recently, they don't provide another route for service out in insolvency proceedings. So it's still an important point. I've got 6 propositions. It's the IBC Act and the winding up petition which clothes the court with the jurisdiction to order service out. As I've just said, the lack of a clear insolvency procedural rule shouldn't hamper the liquidator's access to the court to carry out his duties. The procedural route taken by the liquidator in this case, i.e. a summons in the petition, is the one that's been used in the Bahamas for fraudulent preference claims and indeed in England. D, in the absence of specific rules for liquidations in the company's winding up rules, the rules of the Supreme Court rules apply. Order 11, Rule 8.4 was the correct order, and whether to order service out under the rule is subject only to Order 11, Rule 4, and the discretion of the court. And the bankruptcy rules do not apply.
I should say, I allowed Mr. Sims to go beyond his time by about 10 minutes, so don't fear that I'm
Quite
going
a
to
lot to
stop.
get through,
I
so
won't
I'm
stop
going
you
to
on the
start
dot
skipping
of
my
3 o'clock. If you need to go a little bit beyond it, that's all right.
Very quickly, it's the fact it's a petition and winding up, which gives us the distinction from the cases where the court has refused to permit service out. And that's, if, I won't take you to Masri, but Masri versus Consolidated Contractors International in 2009, that was concerned with obtaining information in the aid of the enforcement of a private judgment in private civil litigation. That's at tab 13 in the main bundle of authorities, and it's page 836. 836.
Thank you.
And that's in contrast, he contrasted, it was Lord Sumption. Was it Lord Sumption or was it Lord Mance? I can't remember. Sorry, it's one of my lady, it was Lord Mance.
It's Lord Mance in
Yes,
Masri.
he contrasted that with the public interests in, in an officer's public examination. In that case, the court refused to clothe the Civil Procedure Rules 71.2 to permit an order for examination against the officer of a corporate judgment debtor. So that's in private litigation, whereas our case is the liquidator fulfilling his public role.
Is it the petition or the order that gives the court the jurisdiction?
My lord, it's the petition that gives the, well, it's section 160 IBC which gives the court jurisdiction, and then the route through is a summons in the petition, but the petition, because it's a winding up petition, affects the whole world.
And that you get some support from the preceding paragraph.
Yes.
It being an originating summons or a petition authorised by an Act of Parliament.
Exactly. I'd like to pick up on what Lord Justice Lewison said in Oxram, having found that Section 423 had extraterritorial effect. He says, given the extent of the court's powers, I would a priori, I can't pronounce my Latin these days, expect procedural rules to exist to enable the court to exercise these powers. The power comes from the statute, my lord. And then you just need to be able to reach the court somehow. I'm not going to take you there, but I would have liked to take you down a trip down memory lane by looking at Atkins Court Forms, and that's bundle 3 at hard copy 65 and soft copy 1163. And those of you who were acting in the Companies Court may remember that a fraudulent preference claim would be made by summons in the petition in the case of in two cases, in the case of a compulsory winding up order and in the case of a voluntary winding up order where a previous order had been given by the court granting general liberty to apply. Where the company was involuntary, it's at paragraph 30, page 65 of bundle 3.
I've got the, I just wanted the paragraph.
And it's paragraph 30 at E. It's the procedural table.
Yeah. Okay.
Sorry, I got page 1163 electronic, and I don't think I could have heard
1163.
Well,
No,
it's not.
it's 1730.
1730.
Yeah, I'm
Thanks.
sorry.
I see. Proceedings as to fraudulent preference. Liquidator applies the declaration.
Yeah. There it is. So where there'd been no previous order giving liberty apply, then the claim had to be made by an inter partes originating summons. And that's basically because if you've got a voluntary liquidation, you don't necessarily have a court file that's been opened. If there's a petition, then you do. Mm-hmm. And this is still the procedure followed by the Bahamas. It is the case of America International Bank Corporation, which is at tab 9, page 157, E page 724. And I should point out there's a nonsense in our case there, where I said it was an IBC company. In that case, it wasn't. It was a Companies Act case. And much the same procedure under the Insolvency Act still exists, actually. My Lord, in our case, I've given the route quite carefully about how you get from the IBC Act to the Companies Act and then to the Companies Winding Up rules, and my primary submission is that the Companies Winding Up rules apply. Then you go to Rule 101, which we saw this morning, which says that when no other provision is made by the Act or rules, the rules of the Supreme Court apply.
I have to say, speaking for myself, I have a little bit of difficulty with the application of the Winding Up rules.
I understand that, my Lord.
Because as I understand, they were made under Section 303 of the 92 Act.
That's correct, my Lord.
Which only gave power to create rules for procedure under that Act, and we're not under that Act.
My Lord, as you pointed out this morning, and Lady Arden as well, you can jump that step by going straight to the rules of the Supreme Court.
All right. Yes, thank you.
So you've got a sort of two-lane highway. One goes via the Winding Up rules.
Yes. And the other one goes straight to
that one's got a roadblock in it, and you just go direct.
Yes, my Lord. And you're helped by, again, in my supplemental bundle, which is the Supreme Court Act, at page 16A, so it's right at the penultimate page. Practice and procedure. The jurisdiction vested in this court, in the court, shall, so far as regards procedure and practice, be exercised in the manner provided by this Act or by rules of court, where no such provision has been made in accordance with the former practice, where there is no former practice in such manner as it seems to the court just and practicable in all the circumstances, So, my Lord, that, I think, enables the court to jump from the IBC to the rules of the Supreme Court.
So you said 16A?
16.
Yes.
Page 16A, Part 4, Practice and Procedure, Section 15 of the Supreme Court.
Yes, I have section 15. Thank you.
Thank you, my lady.
That's right. I've got it.
5 minutes left. I'm talking too much. I've got 15 minutes. Can we go to Order 11, Rule 8? In my case, I've shown that the rules of the Supreme Court can apply where nothing else, where there's no other rule. Order 11, which is at Bundle 1, Tab 4, page 106, E page 673. Order 11, Rule 1, is all the hoops you have to go through, called gateways, to serve a writ out. If I could just remind your lordships by going back to Order 5, which is page 106 and E page 673, very quickly, writs are where there's a claim in relation to tort, fraud, breach of duty, contract. And then Rule 3 is proceedings which must be begun by originating summons. And that's, it must be begun by originating, except where by these rules or by any other act, the application in question is expressly required or authorised to be made by some other means. Rule 4 of Order 5 talks about when originating summons is maybe, a writ may be more appropriate than an originating summons. And then 5, proceedings may be begun by originating motion or petition, but only if by these rules or by or under any act the proceedings in question are required to be authorised to be so begun.
Required or authorised?
Pardon?
Required or authorised?
Yes. And in my submission, in the case of originating motions and petitions, you don't need to go through the gateway, the so-called gateways, in Order 11, Rule 1, because those gateways are all about linking the case or action to the specific jurisdiction. So my friend went through them this morning. Rule 1.1, land situated within the jurisdiction, a person domiciled within the jurisdiction, the estate of a person who died within the jurisdiction, property or trusts where they are subject to Bahamian law, etc. All Rule 1.1 is all providing a pin to the Bahamian jurisdiction. In my submission, the gateway nickname is actually inappropriate. You're making sure that the case is linked to the Bahamian jurisdiction. When you move to Order 11, Rule 8, which is E, page 682, hard page 115, you'll see that subsection 2 is for service out of an originating summons is permissible with the leave of the court. Order 66, Rule 4, is for arbitrations. I made a mistake in our case, thinking it was something completely different because I was looking at our old copy of the White Book. And in my submission, Order 66, Rule 4, which allows, with the permission of the court, service out in arbitration, actually has done away with the need to look at the case that we all can't pronounce, the arbitration case, Aki Bollet. And then 8.3 is where any proceedings are authorised by these rules, or apart from these rules, by or under any act to be begun by originating motion or petition, service out of the jurisdiction of the notice of motion or of the petition is permissible with the leave of the court. You don't need to go to also get the case within Rule 1.1 gateways. It's unnecessary because the case is necessarily pinned to the jurisdiction by the act or statute that the petition or originating motion is brought under. In our case, the petition is brought under a Bahamian statute, which is the International Bahamian International Business Act, Companies Act. And it's odd that this, I can't find anything which actually says that, but it just makes sense. And in Oxerum, it was actually the modern equivalent, although it's not said so. If you read, it's the section, the CPR Rule 6, which also says that it's where an action or case is authorised by statute or by an enactment, and that pins you to the Bahamian jurisdiction. And then sub-rule 4 is what the summons was taken out, that was the subject of this case.
Just on sub-rule 3, was there a provision, it may be that you showed it to us, I just can't remember, in the IBC Act which said that winding up proceedings were to be commenced by petition?
Yes, I think I showed you, I think it was section 95.
Thank you very much. Thank you.
So, 8 sub-rule 4, subject to the arbitration rule, service out of the jurisdiction of any summons, notice or order issued, given or made in any proceedings is permissible with the leave of the court. So in my submission, there's absolutely no reason why the Bahamian court could not give permission to serve out of the jurisdictions of our summons in the petition. And it's not the case that there's no safeguards, because sub-rule 5 says rule 4, 1, 2 and 3 shall apply in relation to an application of a grant of leave under this rule as they apply the grant of leave under rule 1 and 2. And you turn back and it's page 112 hard copy, 679 soft copy to rule sub-rule 4, order 11 sub-rule 4. An application for the grant of leave must be supported by an affidavit stating the grounds on which the application is made, in the deponent's belief the plaintiff has a good cause of action, and showing the place or country where the defendant is or probably may be found. And then, again, another safeguard, no leave shall be granted unless it shall be made sufficiently clear to the court, sufficiently to appear to the court that the case is a proper one for service out of the jurisdiction under this order. So you've got those safeguards, and it's the modern equivalent of that section where in Oxram, Lord Justice Lewison said it's not a proper one in this case because there was the Indian and Singapore arbitration going on.
But I'm sorry, on your case, does Rule 4 apply to an application such as this here? I thought you were saying it's not an application for the grant of leave under Rule 1 or 2.
My Lord, if we go back to Order 8 on page 1 and Rule 4, sub-rule 4, it's on page 116, top of the page, hard copy 116.
Sorry, hard copy.
116.
Yes.
Our application was made under sub-rule 4. That's followed in sub-rule 5.
I follow.
That rule 4.1, 2 and 3 shall also apply to a grant of leave under this section.
I see, thank you.
So effectively you bypass the gateway, but you've still got to comply with everything else.
Yes. Because, and the reason is that the petition has to be in the jurisdiction because that's what petitions and because that's what the winding up is.
So the petition is a gateway. Is that,
Petitions of the...
I understand how you put it. Is that the way it was put in your case, or?
Yes, I think I'm putting it slightly more strongly now than I did in my case.
All right. Thank you.
It was only when I was looking at the sections rather carefully that I thought, hang on, it was looking at why an originating motion and a petition.
I understand how you put it.
Yeah.
Is this now your front runner?
Sorry?
Is this your front runner as a
It's almost a front runner in relation to the proceeding.
Yeah.
My front runner is that the jurisdiction of the court and the power of the court comes from section 160.
Yes, 160, and there's this.
And this is just the route.
Yeah. Then you got right with it.
Can I just ask, I think it was mentioned by Mr. Sims that before the IBCA 2000, the earlier Act dealing with international business corporations did make reference to the winding up rules.
Section 95 of the 1989 Act.
And as I understand it, the 2000 Act made provision for rules, but then no provision was actually made. I just wondered whether Section 15B of the Supreme Court Act is of any relevance, which is the one that says where no such provision is, well, A says in the manner provided by the Act or the rules, B, where no such provision has been made in accordance with the former practice as near as may be. I mean, I'm just wondering if you replace one IBC Act with another and there was a procedure under the old one, whether in those circumstances that would carry over until provision was made under the new one.
Well, normally, if you repeal the empowering enactment, the regulations made under it go automatically. From memory, I think that might be in the Interpretation Act in this jurisdiction.
Yeah. Anyway, thank you.
Yes, I think I've got there. Distinguished Brownlee. The arbitration case, which was Bundle 1, tab 16, which I'm going to call the arbitration case because I can't pronounce Aki Bolaget, in my submission is easily distinguishable. It was a notice of motion to set aside an arbitration award. The underlying relationship was an arbitration, and most arbitrations are outside the court's jurisdiction. The applicants were a French company, the respondents were Swedish. There was an arbitration clause entered in France. The respondents had elected a French domicile. The only connection with England was that the arbitrator was England. There was nothing to pin the case to the English jurisdiction, and therefore it's easily distinguishable. If not following my logic just now, it should be overruled in my view. It was decided over 100 years ago.
Under a different form of rule.
Under quite a different form of the rules.
Didn't have your paragraph 3 in Order 11, paragraph 8.
It was the rule that came into force immediately after the Judicature Act.
Certainly following Anglo-African,
Yes.
which had created this problem.
Yes, Mr. Lady, thank you. Then, just quickly, the argument that in order to use Rule 4, the petition itself must be capable of being served out of the jurisdiction. In my submission, a petition can be served out of the jurisdiction. So, in our example, it would be if Fortis, who was the administrator, actually had shut up shop for any reason in the Bahamas. It may be necessary to serve the petition on the directors or on the place of business, and that is allowed in the IBC Act. And my friend's going to tell me where it is in a minute. It's a winding up Rule 20. So if the winding up rules don't apply, then this isn't relevant.
I mean, I wondered whether the point about Rule 8.3 actually was critical to your case. Because suppose that a petition can only be served on a company within the Bahamas. I thought on your argument about the powers that the court and liquidator would have in a winding up, which would include getting in the assets even if they're overseas, would still mean that you would issue a summons to the court as part of the procedure on the petition, asking for that to be served out under Rule 8.4, whether or not the petition could be served outside the jurisdiction. Have I misunderstood?
No, that's my main argument.
All right.
If it's true that it needs to be linked to the petition, then I say that the petition could, in certain circumstances, be served out. It can be served by leaving a copy with a member, servant of the company, or the registered office. Yep. And then there's the Union Bank of Finland versus Liquidation case, 1997, Monthly Law Reports at, it's at tab 61, bundle 3, e-page 1598, where the court said that in that case, it wasn't a petition, I don't think, the order even though even though the originating process wasn't in fact served out, the fact it could be served out was enough. If I've got everything wrong, then I rely on Lord Diplock's statement in the Olive Casey case in 1971, which is at tab 47, page 800, page 1367, where he says, where an act merely provides for an application and doesn't say in what form the application is to be made as a matter of procedure, it may be made in any way that the court can be approached. My Lord, I've already said in my submission the bankruptcy rules don't apply. The Bankruptcy Act itself says a company shall not be adjudged bankrupt under the Act. In relation to merits and connection, I think I just follow what I've said in my case. The test, it's Seconsar against Bank Markazat 1994. It's quite a low test at this stage in the proceedings. In that case, Lord Gough said that the test for whether there's a jurisdiction is a more than a good arguable case, but all you need to get under the go through the route of sub-rule 4 in order 11 is that there just should be a serious issue to be tried. In this case, the fact that the redemption payment was made in the suspect period gets you home and dry, particularly when you look at the facts in the petition that I took you through right at the beginning. And
the point you didn't mention in your case, I think, when you did in earlier today, was the fact that they had had 2 requests for repayment before this payment was made in July 2002, which were ultimately paid out at only sort of 16 or 18%.
we haven't got the evidence as to exactly when the request was
No,
made.
but I mean, are you relying on that, which is in the petition? It's not in your case, that's all.
I'm relying on the dates, the date when the petitioning creditor asked for their redemption, which was something like the 15th of July, and the fact that the redemption payment to ZCM was made 10 days later. It's just an inference.
No, I understand what you're saying, it's just it's not in your printed case. So.
No, because I only thought of it last week.
No, that's what I thought. Thank you.
So, and the liquidator satisfied, he said he believed it was a good cause of action, and he also gave the address as needed. And then finally, I think I've put in my case the link with the Bahamian jurisdiction. I mean, this is a case where ZCM actually, they weren't just a creditor, they were a contributory to this international big business corporation. They expected to make money out of it, presumably, and they can't just run away from the jurisdiction by saying, oh, you know, we like the Bahamian jurisdiction because we can invest in it and we don't have to pay exchange control and all the rest of it. But we don't like it when it comes to exerting its law and when the liquidator wants to get his money back.
This is the eating
So
your
that's
cake and having it
point.
point that you began with.
And the applicant is definitely the correct respondent to the claim, as you saw. Oh, there's one thing I need to refer you to, and that is the Articles of Association, which are in the main bundle. Where is the main bundle? Yes, but I haven't got the main bundle. Oh, there it is. Tab 15. Sorry. Tab 16, sorry, page 281, page 470. Which is section 206 of the Articles of Association, the exclusive rights. The company shall be entitled to recognise the exclusive rights of a person registered in the register of the company as the owner of the shares, and shall not be bound to recognise any equitable or other claim to or interest in such share or shares on the part of the other persons, whether or not it shall have express or other notice thereof, except as otherwise provided under the laws of the Commonwealth of the Bahamas. So that's why ZCM is the correct respondent in this case. Oh, I'm very sorry, my lord, I went on a bit longer than I should have done. Those are my submissions, unless you have any questions to ask me.
Thank you very much, Ms. Walton. Ms. Parfram, do you follow? Do you have anything to add?
I think my thing has covered all the ones.
Very well. Mr. Sims.
Yes, Lords. Perhaps if I begin with Section 16A briefly, where Mrs. Briggs had inquired about or made a comment on, in terms of whether that fulfilled the gap. Or, sorry, 15, it's 15 in my learned friend's supplemental bundle at page 16A. The reason that this can't cure the problem is, it's at page 16A, is firstly, it's the jurisdiction of practice and procedure. It's not dealing with a territorial jurisdiction. And it is exactly the same as the Anglo-African case, in that under that in that decision, the practice of following the Chancery Court was abolished by the subsequent rule. They didn't put that rule in, and the court said, you know, you can't go back to the old act and you can't adopt it because they did it on purpose. And also, we have rules under 156, and it's also contrary to Rule 1.2 of the Supreme Court rules. So for all those reasons, that section doesn't apply. In terms of the Act, one section my learned friend didn't take you to in the Act, which is at tab 35, which sort of assists in this point, which is at tab 35 at page 1081. I guess that will be in bundle 2. Is section 164.
Sorry, did you say 1081?
Well, the Act begins at 1083, and the particular page that I wish to refer you to is 1167. And you'll see that the legislature there said the provisions of the Companies Act regarding receivers and managers govern mutatis mutandis, appointments, duties, liabilities of receivers and managers and the assets of the companies incorporated under this Act. So they purposely decided not to do it. It's not an omission, the fact that they didn't adopt the winding up rules. I mean, if they did it for receivers and managers, they were obviously thinking about what it was that they wanted to bring in from the Companies Act. So I draw that to your attention. While I have this Act open, just in terms of other sections that perhaps you should have been referred to, if I draw your attention, please, to section 66, which is at page 1122. And my learned friend went to the winding up rules for where to serve documents and saying, oh, it may need to be served out of the jurisdiction. But if you look at section 66, it says any summons, notice, order, document, process, information, written statement to be served on a company may be served by leaving it or sending it to the registered mail addressed to the company as its registered office, or by leaving it with or sending it by registered mail to the registered agent. So you can leave it at the registered office or the registered agent. Service of any summons, notice, order, document, or written statement to be served on the company may be approved by showing the summons, notice, order, document, process, information, or written statement was mailed in such a time to admit it being delivered was correctly addressed by post. So they don't need it to serve out of the jurisdiction. In fact, you will see, I think, at section 37, there is a requirement that the registered office will be in the Bahamas at all times. So you have you have a registered office and a registered agent in the Bahamas, there simply is no need to serve a petition outside of the Bahamas. Nor are there any other statutory claims which would give rise to a reason to serve a petition outside of the Bahamas.
But it might have been blown away in a hurricane.
Well, luckily we many of us Bahamians never leave during hurricanes. We batten ourselves down and we lock down the windows, so somebody will be there to serve. So, just continuing, and in sort of, I think the suggestion was made, and I don't want to confuse the issue. We're not saying that a liquidator can never bring a cause of action. Say that he has a claim, and many of these claims arise, say, against a director, either by tort or breach of contract or whatever. We're not saying that he can't bring a writ and get leave under Order 11. That isn't our case. But our case is that the process, really, they should have brought this case by writ. And if they could have found a gateway under Order 11, they should have. But we're certainly not saying that a liquidator doesn't have the ability in an independent action to resort, like anyone else, to the Supreme Court rules in bringing that procedure. We're only saying, insofar as you're saying that there's a procedure specifically under Section 160, we're saying it's the rules of the bankruptcy rules apply, and that the Supreme Court rules are specifically, by virtue of 2.2, et cetera, disengaged. But it doesn't mean that if there was an independent action brought by writ, that perhaps for any other type of the other claims that a liquidator would have, that he couldn't necessarily bring those claims.
I confess I'm slightly confused by that. I thought that you'd been making a point by reference to the cases which dealt with the old English Rule 8A.
Yes.
Which suggested that to bring yourself within Rule 8A, now you say
Well, I do.
You have to be
You
within.
still have to fall within 11.1. That is the test. So the old English.
But now you're saying you do fall within the 11.1.
Sorry?
Now you seem to be saying that one does fall, in this case,
I don't think a
within
fraudulent preference claim does. But I think if you had another type of claim, say, against the director for misfeasance under 161, et cetera, you could bring those types of claims because there would be a cause of action that would fall within the parameters of 11.1.
So you are saying the liquidator can't resort to writ in this case.
In this case.
Some other cases, perhaps.
Yes.
Is that right?
That is right. In terms of the analogy that was raised of 11.8.3, obviously, I think there was the wrong analysis of that case that none of us can pronounce, particularly me, Akatu-Bole case. In that, my Lord has hit the nail on the head, and my learned friend didn't understand that, is that all the sub-rules are governed by 11.1. With relation to 11.8.3, it's an odd provision that I was just looking at, but it's not much different from Order 11, Rule 1.2, which I discussed earlier was raised in the Orexum case in discussing Harrods. In other words, there's got to be some limitation on it. It's not much different than Order 11, 1.2, which says if you can serve out of the jurisdiction by act, then you don't need leave. It's essentially the same sort of referral, except in this particular case you leave, but it does say that the act itself must show somehow on its face directly that you're meant to serve foreign persons. And so I don't think that can be used to be a route. The Lalakis case was raised, and I didn't take you to it because it's also dealt with in Masri, which points out that it's really an alter ego case. I think Captain Lalakis in that case, I think that's the third-party cost ruling, I believe, and they said essentially he's participating because he's the alter ego of the company that's already a participant. In terms of the reference was given to the Bahamian case, I think of Bank of America case. In the Bahamian case, there were a couple of cases in there, but in those cases, no one's actually ever taken the point. The point wasn't raised. The fact that somebody showed up with a summons, one, it wasn't service to serve out of the jurisdiction, and somebody served a summons and they all just showed up. That doesn't mean it's the right procedure. As far as Atkins goes, and I looked through the whole of Atkins. Atkins doesn't deal with leave to serve out. And there's nothing in Atkins about leave to serve out. And the funny thing about that Atkins excerpt that we were taken to, which is 1163, if you look down the columns, it sort of says the enactment, I guess the section, and then it says the rules. There are no rules. And that's applying to 1949. I think it refers back to the rules, but there is no individual rule referenced to whether that's by summons or originating summons. I do point out, though, that Paramount was an originating application. So was Russo. People don't just serve summonses on foreigners outside of the country with no claim stated out in terms of what it is, with no parameters of safety as to whether it should have been issued. No safeguards. Paramount, Bilta, and ORXM all acknowledge that there needs to be safeguards. There needs to be limitations. So I didn't take you to Bilta or XM because really they just adopt Paramount. But at the end of the day, each of those cases acknowledge that there needs to be safeguards. On my learned friends analysis, there simply are none. If you don't have to go through an Order 11 gateway, Order 11 Rule 1, there simply are no safeguards.
Well, she did point to the fact that you needed leave of the court under Rule 8, Paragraph 4.
You do need leave of the court under Order 8, Rule 4. That is a slightly different test than the one that is prescribed under Order 11, Rule 1. I think that's a general test of whether the court should give leave to serve out. It is not the test, where you have a reasonable cause of action. It is not the test of a good arguable case and having to come under one of the grounds of Order 11, Rule 1, which is set out under Order 11, Rule 1. In any event, as we've said, they didn't meet the threshold in this particular action. Now, I would like to just deal with my learned friend's submission and the written submissions, and she had started, I think, off on in terms of this notice, which we had showed or this appearance, which was by a different company. And just in terms of, I've already discussed it, so I don't need to really develop it further, except in terms of case law, at tab 60, page 1574, which is in bundle 2. This, of course, is the decision by this court in, oh, it's not tab 50, sorry, it is maybe tab 41, which is, no, so where's the Stichting case? It's the Stichting case I'm trying to find. You know where that is? 60? 60, sorry, my apologies. It's tab 60, which would be in bundle 3. Page number is 1574. And this is the 2014 decision. And I simply draw your attention really to paragraphs 29 through 32, which basically, to appear in a liquidation, you have to file a proof to be subject to the jurisdiction. I mean, that's the sort of recognized standard test. Even if and we say, this issue was just raised, there's no facts to explain it, it's a different company, but even if it was the same company, they would have had to file a proof to submit to the jurisdiction. As my learned friend had said, what they did was they appeared to oppose the petition. Well, a petition is filed by petitioners. It is not an act of the liquidator. It is not an act in the liquidation. It is an application to wind up. And obviously they were successful in that opposition, whoever that was, because the matter was stayed. But the point is they never appeared in the actual liquidation. In any event, as I have said, it's a different party. It's the first time it's being raised at this level, at this hearing, and there certainly isn't the factual evidence before the court to be able to deal with it. But again, the paragraph numbers were 29 through 32 of that decision in terms of the laws that it has to be a proof. I also just wish to take you back, if I could, because I was rushing and I didn't actually show you the case, but just so you know where it is, to Parker versus Schuler, which is at tab 15, page 874. which is the Court of Appeal decision. And really at page, the part of the judgment, it's only 2 pages. It starts at 873, and really the part of the judgment is that I wish to take you to is at 874 in the right-hand column. And this was a matter in which they attempted subsequently on the return hearing to change the ground on which they applied under Order 11, and it was held it was not enough in the present case to say that that was not the cause of action endorsed on the writ, nor the cause of action alleged in the affidavit upon which leave to issue the writ and to serve the notice out of the jurisdiction was granted. The claim for non-delivery of goods, it was not until the case came into this court that the plaintiff set up another cause of action that would not be allowed. So insofar as in the submissions of my learned friend, they're now seeking to say, well, maybe we didn't, maybe we should have started by an originating action, treat this as an originating summons, and we come under Order 11F, or we come under Order 11.1.2, that is not permissible at this stage. I also had mentioned the Grouper-Torres case in terms of there being a facility or the availability of Section 122 of the 1914 Bankruptcy Act of the UK. And I thought it'd be helpful just to show you where those paragraphs are, which is at tab 8, which is at page 706.
Well, you better just give us the references because we're beyond when we were planning to arrive.
I'm just going to do that, my Lord. So it's at basically in the ruling is at paragraphs 15 and 16 of Lord Walker, which this is a Bahamian case where the bankruptcy trustee used Section 122 to get assistance in a foreign jurisdiction.
Yeah.
And I'd just like to clarify that also, I think it was stated at one point, if in fact the fraudulent preference, if it is a fraudulent preference and the transaction is set aside, that doesn't make us a shareholder, it makes us a creditor, right? And I think this court recently ruled on that in the, is it the Premio Fund case in 2017.
Sorry, and they bundle reference for that.
We don't have the case, I apologize. It's just during the lunch break I looked it up because I just wanted to double check the point, but.
Thank you.
Yes. But I know it was in 2017.
I'm afraid I'm going to have to ask you, Mr. Sims, to bring your remarks to a close.
I'm wrapping up now. I'm
quickly.
just checking with my junior
Yep.
members if there's anything else I need to mention. Oh, yes, sorry, the dates of the redemption.
Yes.
Which are in evidence. We actually, our clients had applied for the redemption as of May 31st, 2002. The value date was June 30th, 2002, so it was well before these chaps had even put in their redemption, and they got partly paid. And you'll find that at page 147 of tab 15, 147 in the record, in the affidavit evidence. Yep. So the last point really that I wish to address you on is this question of that there were all these international participants. The reality is in the UK, before 1962, there were many international participants dealing with companies. That doesn't change the law as to whether or not those participants are subject to a fraudulent preference to be served outside of the jurisdiction. And insofar as they are subject to that jurisdiction, it doesn't take away the safeguards which they should be afforded, ensuring that there's a proper case to be brought against them. A good arguable case has been set out. So, my lords, I don't know if there's anything else that I can assist you with.
I think not, Mr. Sims, but thank you very much indeed for your assistance.
I was assuming that I was of assistance, so.
Yes, I was just about to thank.
Make that assumption.
I was just about to thank all counsel for their assistance. We'll take time to consider your submissions and decide what advice we will humbly tender to Her Majesty.